My name is Elize Shakalela, and to the stage, I'll just call upon Mr. Carlo Mcleod, the Deputy Director at the Ministry of Mines and Energy. Please join me on stage. Now, before I go on to my panelists, the production of oil and gas is set to take place offshore. A number of things can go wrong. The production or the drilling or the exploration can cause water pollution, oil spillage, which can cause water pollution. The combustion of the exploration and the drilling can cause air pollution. And it can also affect the livelihood, because I know Lutherans, it's taking place in the Orange Basin. I know Lutherans as a sea town, which is a fishing town, is explaining that most of the fishermen there, or most of the livelihood there, comes from the fishermen, depend on fishing. That is why we need the law. We need the law to regulate the industry, to control the industry, to set the standards and the modalities under which the industry should actually cooperate, as well as to determine who the participation would be in terms of what the participation would be to the locals, what or to what extent the participation would be to the international. In the event that there is no law, then we rely on contracts. Now, the downfall of contract is that they are only enforceable inter se between the two parties. Right now, we have a lack in legislation in terms of what you call in oil and gas decommissioning. In the mining sector, we call it rehabilitation. We also have a gap in terms of local content. There is no regulations on the local content. So over to you, Mr. Mcleod. In terms of Section 14 of the Petroleum Act, there is, to a certain extent, a requirement there that all companies, petroleum companies, should comply with local content. However, at this place, there is no regulations, modalities in place. How do you foresee, from the government point of view, the implementation of local content? I understand that there is a local content policy. Why policy, in other words, and why not law? Straightforward, to give effect to Section 14 of the Petroleum Act.
Thank you. Am I audible? Okay, like my colleague Shakwa earlier indicated, that there are provisions, while limited, but there are provisions that speaks to local content indirectly. It is not a instrument that has been, today. It has been part and parcel of the law since 1991. However, we believe that the provision needs to be amplified, it needs to be strengthened, hence the need for us to come up with a policy, basically to ensure that the areas that we want to see strengthening most is basically being provided for in the policy, which is the provision of workforce development, which is labor, goods and services, and to a certain extent as well as participation in terms of ownership as well as financing. So this is what the policy entails to achieve, and once that is passed as an official document, this policy will then be further translated into legislation, that is now into the Act, and then regulations will then be drafted in order to give more, finer details on what we want to see. So the policy in itself is just a broader based format for Namibians, for government, the oil industry to understand what the intent and the purpose is that we want to achieve, and then the law will make it kind of basically more of an enforcement type of a document, an instrument. We would, through this process, want to have, the cooperation of the oil companies as well as all other players, stakeholders within the oil and gas sector, directly affected and indirectly affected, to see to it that this policy becomes a meaningful instrument so that when it's translated into a law, it is a kind of a mirror of the aspirations that we would want to achieve. And so far we have received a lot of good reviews from our engagements that we had earlier this year. The policy was launched, the draft was launched, and we received a lot of good feedback from a number of stakeholders. And the policy is still under consideration. We are planning to go into the regions because that is a requirement before the policy is adopted, to have a broad-based consultation with, the people at the grassroots level, because this policy or this industry, this sector is also going to affect and impact, the people on the street. So that is one way of us trying to manage expectations and go out there and tell the people that this is what the oil and gas sector is trying to achieve. A lot of people do not understand and appreciate the sector. So this policy will be, and the efforts of us going out there in the region would be an educative process, but it's also an opportunity to hear and solicit, feedback from, the most important people, which is the citizens of this country. Thank you.
Thank you, Mr. Mcleod. Over to you, Prof. Ruppel. So how can we use the law as a vehicle to basically create synergies between the global north and the global south in the just transition to renewable energies with the right tech and capacity?
Oh, wow, that's an evening-filling question. I think there are different spheres of the law. Of course, we have the domestic law, and it has been mentioned before that, of course, communities have to be involved, local content, community rights have to be protected, but also the commercial side of things has to display the government's intention. And there, I think it is important that the law is being utilized different than perhaps it was utilized in the past, namely as a reactive regulatory instrument rather than a proactive regulatory instrument, asking what do we want to regulate, for which purpose, which targets do we want to achieve in order to fulfill our policy plans. That is the domestic law. But internationally, there is also a lot of opportunity space. For instance, in the negotiations of the Conference of Parties to the United Nations Framework Convention on Climate Change, where the global community is very clear on what must be done to fulfill the 1.5 degrees centigrade goal, but knowing that it is complicated, there has to be a price tag attached. For that purpose, countries in the global north have committed themselves to provide, for instance, technical and other assistance to developing countries in the global south with an amount of up to $100 billion per annum. So far, that has not been dished out. But personally, I'm convinced that especially a country like Namibia, with its pristine environment, with its footprint, with its ambitions now, can be a perfect negotiating example, being one of the first accredited members of the Green Climate Fund, by the way, of the United Nations, in order to tap some of these funds to do exactly that, namely to utilize the highest standards, the best possible technologies, the best capacity transfer opportunities in order to assist the global intention to reduce greenhouse gas emissions and at the same time reduce employment and empower its people and lead Namibia to a higher level of development.
Thank you, Prof. Over to you, Mr. Nyambe. We've heard that we have a local content policy and that we are moving towards developing the regulations, or rather an act and then the regulations. How do you envision these regulations to look like, or rather the act to look like? What do you want to see clearly in that particular legislation in order to really reflect the skills and that the skills transfer really happen on the ground in terms of local content?
Thank you, Elize. I think we can already tell from the draft local content policy which direction the government through the Ministry of Mines and Energy is going with regards to the local content provisions. You see that the four pillars or the major pillars of this policy, which is what we believe will be reflected in the Act and the regulations, is to first promote the participation of Namibians in the industry, to maximize the employment, the transfer of skills and technology, as well as to promote the ownership of Namibians in the industry and the businesses which will be involved in the oil and gas industry. So when you look at that, you can only ensure that happens, as you have indicated yourself earlier on, when the policy is translated into an act or the regulations. In that way, there will be expected actions from the industry in terms of what they need to do with training, with secondment, in terms of what is the minimum percentage of participation of Namibians, whether it's equity or it's in JVs, that will be also specified. And then as well as the monitoring and evaluation provisions. And there will be targets also that this is the target we want to reach in terms of employment of Namibians, or this is the target we want to reach in terms of promotions of Namibians from these lower ending skills to the higher ending skills. And obligations are put on the companies that you need to do this by this and this. Those who don't comply, there will also be sanctions. So we expect a legislation which has all these components. However, like I emphasized earlier on, we would need a competent body and authority to enforce this, to do the monitoring and an evaluation. Hence, I was talking about an independent upstream regulator. Thank you.
Thank you so much, Shakwa. Then over to you, Corinna. How do you foresee government monitoring right now, currently? We are already talking about oil and gas. It's a niche market. How do you foresee them right now basically monitoring a policy document to ensure effective participation of community members, firstly? And as the lawmaking process, as a lawyer, the lawmaking process is a process that takes a number of years. And right now we are a policy document, meaning that will still take about 6 to 7 years-ish in order to have the act implemented. And then the downfall of that is that most of the time in Namibia, we never do things parallel. We've heard that we'll first do the act and then start drafting the regulations. At the moment, right now, how do you foresee monitoring and evaluation of a policy document?
Yeah, it is. This is a difficult one. For me, there are many ways to implement a policy. Government can establish regulatory bodies that are responsible to monitor and evaluate the policies on local content. Compliance mechanisms can be clear guidelines, regulations or reporting requirements that the companies involved in oil and gas need to comply to. Stakeholder engagements, a policy. Transparency and accountability, a policy. Community empowerment in policy. Efficient grievance mechanisms, a policy. But we cannot avoid that a policy is not binding. We've got so many policies, and when it comes to implementation, Namibia fails. Namibia fails when it comes to implementation. And unless there's a law that forces that implementation, there is no liability. Not between the government and the community member, not between a corporate or company and the community member. So it's really not enforceable. It's a great idea, and intentions are great for, attracting investors. But when it comes to enforcement, the community will not be able to use it.
Perhaps I see the Deputy Director of MAB also want to add on that question, so please, you have the floor.
I want to just add some more light on that question. What the policy is envisaging is that we would want to see the oil companies upon application, and once the license is issued, you should basically prepare a plan, a local content policy plan, which is basically submitted as part of our scrutiny process. We want to see how best you would add value to the country in those respective three areas: labor force development, goods and services, and that will be part of your social license to operate. And it goes as well to the production stage once you want to apply for a production license as well. And added to that as another layer that obliges the operators that at TCMs, which is a biannual a meeting, technical meeting where we sit as government as representatives of the rights to these particular resources with the oil companies and their partners, and then they account to us on the work program and the progress that they have basically carried out throughout the 6 months interval process. And during that, we would also want to see your progress as an IOC, as an investor. What progress have you done in order to implement and to see to it that local content policy is being adhered to? Further to that, another layer is that in the Act, and just to help also understand, we already have an amendment bill already. We are not going to wait 6 years. We have an amended regulations already. So once the policy is approved, we are going to run with that bill. And we are going to run with the regulations. So we are not going to wait until the policy is accepted and then wait another, as a normal process, 2, 3, 4, 5 years for the bill to come into effect. We have done that homework already. So what the Act envisage, or the bill as it is, there will be a compliance or non-compliance provision in that bill that will eventually become an Act. Meaning that if an IOC does not comply to whatever is, they're obligated to, the minister will be able to issue a non-compliance notice. And this will also be then gazetted, and the world will see this IOC is not being a responsible corporate citizen. That is the another layer of protection that we want to guarantee.
Thank you so much, Mr. Mcleod, for clarifying that. I'll now move over to you, Graham. So basically, you spoke about ET. What are some of the lessons that Namibia can draw from ET, especially in implementing the Access to Information Act? How do you envision the implementation of that, and what is the first step now that we need to do as a country, seeing that we are not a signatory yet, but however, we have an Access to Information Act that is, I think it's at the final stage, waiting for President's signature. Oh, it's already signed. So how do we implement that in relation to ET, especially in this extractive industries?
Yes, well, I think Namibia is in a good position to join the EITI in the near future.
Yeah.
We'll have to see what the consultants say next week, but one of the big advantages of joining the EITI is it improves credibility and it improves confidence. That's for the investor, but also for the public in the country as well, because they know that certain information will be made public and they can have confidence in the process going forward. And Namibia is in a good position. We are a democracy. We are regarded as having the freest media in Africa. So these two things combine, access to information and joining the EITI, the Extractive Industry Transparency Initiative. I think it will play into our interests in terms of having a credible oil and gas sector going forward and avoiding what we talked about in terms of the resource curse. So huge advantages to moving in this direction. The world is moving in this direction anyway. The FATF, the anti-money laundering stipulations we have to follow. Yes, it's frustrating, we all have to fill out more forms at the banks and so on, but these things are now seen as standard and necessary in the 21st century. So, let's make sure that we are a global leader on this and not hang back and try to keep certain deals or issues, hidden. And obviously, the conversation around the hyphen feasibility agreements that was recently signed is very relevant here. And I just caution, I hear hyphen dismissing just the possibility of publishing offhand.
Yeah.
Yes, of course, there's room for compromise. If there really is an argument that there's something commercially sensitive within an agreement, maybe it can be redacted. Maybe it would be enough to have a comprehensive summary. But we need to be moving into this direction of open contracting. I know the private sector, Chamber of Mines and so on, have balked at this in the past, but this is the way the world is going. Let's follow the global standards. It's in the interest of everybody.
I'll come back to you later on, but let me go to Mr. Nyambe now. Mr. Nyambe, we've heard from the Deputy Director from MME that in this legislation, they envision to have a non-compliance clause there, where companies would be issued with their certificates of non-compliance and published on a certain website, or at least issued. And I imagine it has to be published in order for the world to see, right? So what other enforcement clauses do you envision to see in that legislation? It could be penitative clauses. Like, what do you think are the best clauses that you would find in the best local content act and the enforcement thereof?
Thank you. When it comes to the punitive measures, it will depend on the extent of how they have breached that legislation or regulation, and what is it was supposed to be rectified. So there will be a variance in terms of penalties. That's what we expect, which will be imposed, because you can't issue the same penalty for different offences. So some of them will be the lesser ones where they have to, maybe some they are cautioned and given an opportunity to rectify. Some of the penalties will be you pay a certain fine. Some of the penalties is you might lose the severe ones, you might even lose your operating license. So it will vary depending on the severity of that offense. But they need to be penalties, because if you have done something, you need to be held accountable. And then we will need the personnel and the professionals, the team, to be able to ensure that this is this is meant to work.
Ms. Corinna, in terms of in other companies, or rather even in other countries, mining companies are paying for biodiversity offset, the maintenance of biodiversity, because we all know, as I said, a number of things could go wrong, especially when exploration is happening offshore. There could be pollution, basically even causing degradation to the marine resources ecosystem. The fishing industry could be severely affected. What do you envision to see as some of the key sort of like initiatives and benefits that the mining companies can actually give or afford to community members in order to ensure that tourism, because most of the time in Loderet as well, tourism happen, fishing happen. So how do you envision mining companies to still ensure that the livelihoods, of course we know that there are going to be some people employed in the sector now, but then how do you envision that they still maintain the biodiversity offset, they still pay for ecosystem services? Like, how do you envision the coexistence of that in this upcoming industry, also in order to avoid the resource curse?
Elise, you're really targeting me, I think. For one, I cannot speak for the communities. This is a conversation. These are the conversations that need to be had with the people that will be affected by the oil drilling or by the effects of the activities. And you say it might happen. It's inevitable. There will be pollution. Whether it's small, whether it's effective, that is another conversation. Insofar as biodiversity is concerned, of course there should be mitigating factors. And of course this should be indicated in your management plan, isn't it? Also the cost thereof. I mean, they should be able to deal with foreseeability, foresee what the harms are, what the degree of these harms are, and what the cost would be to actually fix it, either then or there, or rehabilitate it within a period of And these are the kind of information, this is the kind of information that I think needs to be shared with the communities, because they need to make a decision. Do they want to stay there and share the risk, or do they want to move away and then be placed in a position where they can actually continue their livelihood either on the same basis or on a higher standard somewhere else where they will not be affected. In the past, and we can look at the trend, oil and gas exploration, I mean, all over the world, it's always been this undisclosed, secluded activity that's been going on. It is time for coexistence. It is time for transparency. It is time that we deal with issues honestly. I mean, you can be transparent even about the bad effects, and it still wouldn't matter. But if you don't involve the communities in those decisions, then that's where the problem comes from.
Yeah. Oh, okay. Just a quick one to Professor Ruppel. You now identify yourself as a sustainable lawyer, sustainable development lawyer. What are some of the key sustainable principles that you think we should actually consider in implementing this legislation or governing oil and gas in general, not just local content, but of course there would be a number of legislation that would need to be developed, that needs to be, if it's not a new legislation being developed, then definitely it's a regulation that needs to be developed. There's a decommissioning legislation that needs to be developed. There's a rehabilitation, decommissioning for offshore, rehabilitation for onshore. And so what are some of the key principles in the development of this legislation that we need to adhere to in terms of international law?
Can you hear me?
Yes.
In the past, many African countries made a lot of concessions when it came to new developments in order to attract investments, to compromise on the interests of its people, especially the most vulnerable, to compromise on the protection of the environment. I think Namibia is now at a state where this is no longer needed. Namibia can dwell on upholding the highest possible standards when it comes to international investment when it comes to new developments. Namibia should not go for the live now, pay later principle. Prevention is better than cure. Precaution is important. And also to select partners, and someone mentioned honesty and integrity this morning, carefully. To monitor those partners and to monitor the intentions, so that not the interests of the most vulnerable people are sold out first. This has happened on this continent, unfortunately, over and over again. I think many corporate players have corporate and social environmental responsibility written high on their agenda.
Yeah,
That
ESG now.
ESG is key. Transnational liability is also an issue where mother companies somewhere in the global north are now being held more and more accountable for damages they have caused